Business and industry will come to order. The clerk will call the roll.
Chairman Longoria.
Present.
Vice Chair Vasut. Representative Niave Criado.
Here.
Representative Lambert.
Here.
Representative Hinojosa.
Here.
Representative Gonzalez. Representative Cole.
Here.
Representative Isaac.
Here.
Representative Frazier.
Here.
Vice President.
A quorum is present. Members, I want to thank each of you for being here today, as well as members of the public that are watching both in person and online. As a reminder, anyone present wishing to testify before the committee, please register at the iPad kiosk located in the hallway behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. Members, it is the chair's intention to take up pending business upon the completion of Madam Chair Thompson's bill. So with that being said, the chair lays out House Bill 102 and recognizes Dean Thompson to explain the bill.
Mr. Chairman, and may I do the bill from this position, please?
Yes, Madam Chair.
Mr. Chairman and members of the committee, thank you for letting me bring this bill before this committee. We live, as all of us know, in a state that prides itself in having one of the best business climates in the nation, yet some employers fail to take timely action to address safety concerns in the workplace, subjecting employees to a dangerous work environment and are not equally held accountable for doing so. Texas law forbids employees from suing their employers if they are subscribers to the workers' compensation system, but a surviving spouse or an heir can bring a gross negligence lawsuit if the reckless conduct results in the employee's death. My constituent, Christian Fitzgerald, 26 years old, was killed at the Port of Houston during the course of his workday. He was single and he had no children. When his parents attempted to sue for gross negligence, the court denied them any recourse because of the way the Texas law is currently written. Members, let me just say, this is not the first time this has happened. I want to call your attention, if I may, back to June 2020. The Texas Supreme Court case of Movac versus Escobedo. Justice Guzman called upon the legislature to align the Workmen's Compensation Act with the wrongful death statute so that parents who have lost a child can recover exemplary damages. Her concurring opinion underscored the ongoing danger to workers because some workers are treated as more expendable than others, and the consequences of employers that have evaded responsibility of workplace laws have failed to materialize. House Bill 102 will close this unjust loophole by allowing the estate to bring a cause of action and recover exemplary damages. Mr. Chairman, my constituent, Tamaria Fitzgerald, the mother of Christian Fitzgerald, is here to offer her testimony. I'm available for questions of this extinguished committee, and I would like to reserve the right to close, please.
Members, any questions for Dean Thompson? Thank you, Dean. We'll proceed to testimony.
Thank you, Mr. Chairman.
Chair calls Tamara Fitzgerald. Chair recognizes Vice Chair Vasut. And we show you registered as Tamara Fitzgerald on behalf of yourself testifying for the bill. Is that correct?
That's correct.
Thank you.
All right. Good morning to everyone. My name is Tamara Fitzgerald. I'm here to talk about how crucial House Bill 102 will impact the lives of the community. My son, Christian Fitzgerald, he was killed on August 23rd, 2017. Because the company that he worked for, Cooper Ports of America, they failed to provide a safe working environment. House Bill 102 can start the process of holding all companies accountable to the way they conduct business. More importantly, House Bill 102 will get companies to hopefully implement an immediate call to action by implementing policies that can effectively keep their workers safe. Without House Bill 102, Cooper Ports of America and other companies, they just pay an OSHA fine and continue to get away with hurting, maiming, and killing employees. And at the Port of Houston, when OSHA comes, everybody is aware. They have to notify the security when they come to the port. What's to stop the Cooper Ports of America from knowing? Absolutely nothing. There's nothing that they have time to do whatever they need to do to cover their tracks or do whatever they want to do because they have time because there is no secret notification. On August 23rd, 2017, my life changed forever because of my son's death. My life and the life of my family has been forever changed. Christian was crushed to death by a heavy lift machine that was owned and operated by Cooper Ports of America. Cooper Ports of America allowed one of their heavy lift operators to operate a machine that should have never been allowed to be in service. The forklift was too old and not in compliance with federal standards. The forklift had no backup alarms, no side or rearview mirrors attached. As a result of not being able to hear this machine, Christian was crushed to death, and another truck driver that was with him was severely injured. The forklift operator complained to his superior at the beginning of the shift that the brakes didn't work on that particular forklift. However, the forklift operator was allowed by Cooper Ports of America to operate the heavy lift anyway. No brakes, no backup alarms, no mirrors. On August 9, 2022, it was reported to me that our clerks and checkers are the leading fatalities within our International Longshore Association. Sadly, Christian, who was a member of the International Longshore community, is not the only life that has been lost as a result of companies like Cooper Ports of America failure to act. If House Bill 102 has been in effect, maybe, just maybe, Cooper Ports of America would have made sure the forklift was perfect and made sure that the forklift operator was not impaired at the time of this accident that resulted in one injured truck driver, one dead employee, an entire workforce of traumatized witnesses. Some who saw this never came back to work. My son, Christian, he left this earth not having a family of his own. Christian was a single, unwed man. I would never know his children. I would never be able to see my son have a family of his own. Christian's life was just simply cut short by Cooper Ports of America's bad policy of working with bad equipment. I pray that you pass House Bill 102 to add strength to our workforce. If laws are not enacted to severely penalize companies like Cooper Ports of America, just maybe my son will be here today. If these laws are not passed, these companies are not going to change. They're not going to change. Bad companies who allow bad equipment in the workforce should not exist. Bad companies must be put out of business for the greater good of mankind. House Bill number 102 will send a strong message that companies will have to create safer work environments so that workers like Christian can safely return home. Thank you to everyone for creating this change and to help in the passage of House Bill 102 for working families and those that are not here to speak for themselves, like Christian Dion Fitzgerald.
Members, any questions? Sorry for your loss, and thank you for coming to testify today.
Thank you.
Thank you. Chair calls Robert Hand. And we show you registered as Robert Hand on behalf of yourself testifying for the bill. Is that correct?
Yes, Mr. Chairman. Good morning, Mr. Chairman, members of the committee. My name is Robert Hand. I'm here speaking on behalf of myself in support of the bill. I'm also Ms. Fitzgerald's lawyer. You heard some of the facts of her son's tragic death. I'd like to add that the forklift machine, it was way out of order, no rear view mirrors, no backup alarm, unworking brakes, no horn. In addition to that, the operator tested positive for marijuana. It was found he was impaired at the time of Ms. Fitzgerald's son's death. HB 102 will close a loophole in our law that excludes people like from Ms. Fitzgerald from bringing a claim for gross negligence against employers. Under the current state of the law, whether employers like Cooper Ports or others who kill their employees through gross negligence, whether they're held accountable is not dependent on their level of conduct, it's dependent on who the victim is. If the victim is married or has children, the spouse or the children can bring a claim. If the victim is single, unmarried, and without children, like Christian Fitzgerald was, his family members are barred from making a claim. And those employers never even face a jury to get to judge their conduct. This loophole stems from some archaic legalese language in the Labor Code. It says that only spouses or heirs of the body are able to bring the claim. Heirs of the body has been interpreted by the Supreme Court to mean natural children of the employee. It stems from the first Wrongful Death Act in Texas, signed into law by Sam Houston in 1860. It was then incorporated in the Constitution in 1876, and then it found its way into the Labor Code in 1913. It's remained unchanged since. Since 1913, our wrongful death statute has been amended to add parents as beneficiaries, and the survival statute has been enacted to allow family members of deceased single people like Mr. Fitzgerald from bringing claims. This archaic language remains in the Labor Code, which prevents Ms. Fitzgerald from bringing the claim, and that's what this bill seeks to remedy. One of the things that Ms. Fitzgerald mentioned is, Dean Thompson mentioned, was Justice Eva Guzman's concurring opinion. She called on the legislature to make a change like this bill, and I'll leave you with two things. The first is her concluding remarks in that opinion. She said, in a perfect world, employers would do the right thing simply because it's the right thing to do. But we don't live in a perfect world. We live in a world that requires laws, regulations, and disincentives to help ensure employers don't do the wrong thing. Without meaningful consequences for engaging in prohibited conduct, laws are not effective. On that score, the Workers' Compensation Act has a loophole that unwittingly permits employers to engage with impunity in unsafe practices. I believe the tragic circumstances presented here make a strong case for aligning the Workers' Compensation Act with the Wrongful Death Act, and I call on the legislature to do so. The second thing, Ms. Fitzgerald mentioned OSHA. The OSHA fine for Christian's death was $12,394. That sum is nowhere near sufficient to deter the wrongful conduct that led to his death. That's why this change in the law is necessary. I'm happy to answer any questions y'all may have.
Representative Cole.
You said the wrongful death statute applies to parents?
Yes, ma'am. Under normal circumstances, when a claimant brings a lawsuit against a defendant who is not the employer, the Wrongful Death Act applies, which includes parents as beneficiaries in addition to spouses and children.
Do you know when that was amended?
I do not know when parents were added, but it was a long, long time ago.
Okay. Is there any federal law on point?
Not that I know of. Most of these death claims are governed by state law because at common law, there is no cause of action for wrongful death. It is all a creature of statute. It is all created by statute in the legislature in each state.
Thank you.
Members, any questions? Madam Chair Nyabe.
Thank you, Mr. Chairman. Thank you for your testimony, and thank you also to the mom who testified about your son Christian. I'm sure that wasn't easy for you. I wanted to ask you to get a better understanding because we have subscribers or companies who have the workers' comp who pay into that, right? So can you clarify for us, I don't practice workers' comp. With respect to workers' comp, if they're not what typical damages do they get in circumstances where there aren't exemplary damages? And in this case, I guess, can you explain to us what exemplary damages are?
Sure. In a normal case against a non-subscriber to workers' compensation, a grieving family member would have the whole gamut of damages available, including loss of companionship in society and also loss of earning capacity and lost wages of the deceased, and love, comfort, and support, things of that nature. This specific cause of action is a very narrow circumstance in which the employee dies and the employer is a subscriber to worker compensation insurance, and the only claim that is available is a claim for exemplary damages, which is punitive damages, which is capped by statute. And in this circumstance, for people like Christian, who was single and had no children, the effective cap for a claim like his is $750,000 because the estate is not going to recover lost wages. They're not going to recover any economic damages other than perhaps a burial or funeral expenses, which are quite minimal. So that's the gist of the damages that are allowed.
So gross negligence would be something so extreme or severe, or I'm sure that's not the proper standard, but whatever the standard is, like where they knew or should have known.
Yes, and I handle many of these cases currently and in the past, and they are difficult cases because of the high standard that you have to meet. First, you have to prove by clear and convincing evidence, that's a higher standard than the preponderance of evidence, which is normal, that the employer had actual knowledge of an extreme degree of risk of bodily harm, and with knowledge of that risk, nevertheless proceeded with the conscious disregard of life, safety, and welfare of others. And on top of that, you have to prove that they did that to a unanimous jury. The jury has to be unanimous. So
it would be hard to even get exemplary damages, period. It's a high burden, and it's only for certain employers that aren't,
correct.
that
And
just
it-
happen to subscribe to workers' comp, right?
Correct.
Okay, I
And
just wanted to
it's-
clarify.
It's meant
Thank
for
you.
very egregious cases like Ms. Fitzgerald's, and those are the type of cases that spouses and children can bring right now, but parents and other relatives are excluded.
Members, any questions? Thank you. Chair calls Laura Tamez. And we showed you registered as Laura Tamez on behalf of Texas Trial Lawyers Association testifying for the bill. Is that correct?
Yes, good morning, Mr. Chairman, members of the committee. My name is Laura Tamez. I am the president of Texas Trial Lawyers Association, and I am testifying on its behalf for the bill. So there is no worse nightmare for a parent than the death of a child, no matter their age. And this bill is good policy and a pathway to justice for parents because it serves as an incentive to improve safety cultures to protect Texas workers. So in that vein, because the gross negligence standard is so high, this is for the cases where the employer places Texas workers in an extreme degree of harm, where the potential and the magnitude for death is high, when there were other available means to protect workers from death or catastrophic injury. Therefore, the bill is good policy because it deters bad conduct. We applaud Dean Thompson for her actions in protecting Texas workers. I'm happy to answer any questions.
Members, any questions? Thank you very much.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 102? If not, the chair recognizes Dean Thompson to close on her bill.
Mr. Chairman and members, thank you so kindly for listening to this painful testimony of my constituent. I know that she's seeking justice for persons who would be caught in the same or similar situation that her son was. It is just a matter of fairness that we we change the law so that persons will be able to address this kind of thing. Everybody look forward to, a long life for their children. And one of the things they look forward to is having grandchildren, whether they have them or not. That's something that they look forward to. Just the opportunity to be able to hold them, to see them grow up, to see them graduate from college, to go to their first prom. All parents look forward to seeing grandchildren, maybe just at their birthday parties. And so did Mrs. Fitzgerald look forward to her son having children as well. It is incredibly painful to lose a child. We all know that. And I hope that none of you ever go through this similar experience that my constituent has gone through. Justice should not be denied to parents who seek to hold employers accountable for gross negligence when their child dies in the workplace. We're not just asking or taking something from companies, but we're reminding them that if they have employees, they should provide a safe workplace. Mr. Chairman and members, I ask for favorable consideration by this esteemed committee.
Thank you, Dean
Thank you.
Thompson. If there is no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. Thank you, Dean Thompson. Members, we're going to take up pending business from last week. Chair lays out. Representative Hinojosa?
Oh, no, I'm ready to.
Oh, okay. Chair lays out House Bill 207 is pending business, and this was the bill by Representative Chairman Murr relating to the exclusion of certain conveyances from classification as sham or pretended sales. Chair moves that HB 207 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendar. Clerk will call the roll.
Chairman Longoria.
Aye.
Vice Chair Vasu.
Aye.
Representative Nave Criado.
Aye.
Representative Lambert.
Aye.
Representative Hinojosa.
Aye.
Representative Gonzalez. Representative Cole.
Aye.
Representative Isaac. Representative Frazier.
Aye.
9 ayes, 0 nays.
There being 9 ayes, 0 nays, and 0 PMVs, the motion prevails. Chair lays out House Bill 2314 is pending business, and this was the bill by Chairman Canales relating to the filing death benefits claim under the workers' compensation system. Chair moves that HB 2314 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chairman Longoria.
Aye.
Vice Chair Vasu.
Aye.
Representative Nave Criado.
Aye.
Representative Lambert.
Aye.
Representative Hinojosa.
Aye.
Representative Gonzalez. Representative Cole.
Aye.
Representative Isaac. Representative Frazier.
Aye.
9 ayes, 0 nays.
There being 9 ayes, 0 nays, and 0 PMV, the motion prevails. Chair lays out HB 2316 is pending business relating to the employment of certain peace officers, detention officers, county jailers, or firefighters who are injured in the course and scope of duty by Chairman Canales. Chair moves that HB 2316 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chairman Longoria.
Aye.
Vice Chair Vasu.
Aye.
Representative Nave Criado.
Aye.
Representative Lambert.
Aye.
Representative Hinojosa.
Aye.
Representative Gonzalez. Representative Cole.
Aye.
Representative Isaac. Representative Frazier.
Aye.
9 ayes, 0 nays.
There being 9 ayes, 0 nays, 0 PMV, the motion prevails. Chair lays out HB 2574 is pending business, and this was a bill by Representative Lambert relating to the requirement for notice advertising in the sale of property to enforce self-storage facility liens. Chair moves that HB 2574 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Vice Chairman Longoria.
Aye.
Vice Chair Vasu.
Aye.
Representative Nave Criado.
Aye.
Representative Lambert.
Aye.
Representative Hinojosa.
Aye.
Representative Gonzalez. Representative Cole.
Aye.
Representative Frazier. Representative Isaac. Representative Frazier.
Aye.
9 ayes, 0 nays.
There being 9 ayes, 0 nays, 0 PMV, the motion prevails. And lastly, Chair lays out HB 2926 is pending business. Representative Hinojosa offers a committee substitute to HB 2926, and this is the bill by Chairman Turner relating to the certain claim for benefits or compensation by certain public safety employees and survivors of certain public safety employees. Is there objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. Chair moves that HB 2926 as substituted be reported to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chairman Longoria.
Aye.
Vice Chair Basut,
Aye.
Representative Nave Corrado,
Aye.
Representative Lambert,
Aye.
Representative Hinojosa,
Aye.
Representative Gonzalez, Representative Cole,
Aye.
Representative Isaac, Representative Frazier.
Aye.
9 ayes, 0 nays.
There being 9 ayes, 0 nays, 0 PMBs, the motion prevails. All right, back to our current business. Chair lays out HB 2153 and recognizes Chairman Kemple to explain the bill.
Good morning. Thank you, Mr. Chairman and members. This bill pertains to the city of Schertz and the city of Schertz only. 1963, there were 200 lots that were zoned residential. Over that time, nothing's been developed on them. They've turned into a literal dumping zone. This bill simply amend the property code to let these 200 lots be rezoned only if it is approved by a 67% vote of the property owners. I'll ask for the right to close, Mr. Longoria.
Members, any questions for Chairman Kemple? All right, we'll proceed to testimony. We don't see anyone registered, so is there anyone else who wishes to testify on, for, or against House Bill 2153? If not, Chair recognizes Chairman Kemple to close on House Bill 2153.
Mr. Longoria, thank you. Schertz, Texas only. I'll close.
Is there any objection to the bill? Not, the bill will be left pending. Is there objection? Chair hears none. The bill is left pending.
Thank you.
Thank you, Chairman. Chair lays out House Bill 1957 and recognizes Speaker Guerin to explain the bill.
Thank you, Mr. Chairman and members. It's an honor to be before you today. House Bill 1957 affects Section 22.353 of the Business Organization Code, which requires nonprofit corporations to make available to the public its records, books, and annual reports of the corporation's financial activity. It was enacted to ensure nonprofits are utilizing their funds properly. There's a growing concern that the law is being misused to harass nonprofits, forcing them to disclose sensitive information that should not be subject to disclosure under this statute. 22.353 does not properly define what documents are included in the corporation's records, books, and reports. Nonprofit organizations conduct various types of transaction and maintain documents that can be very sensitive in nature, such as contract agreements, personnel files, and sponsorship information. The lack of specification can lead to many nonprofits being confused as to which documents should be disclosed. The committee substitute for 1957 seeks to eliminate this ambiguity and clarifies which documents a nonprofit must make available to the public for inspection and copy.
Representative Frazier offers a committee substitute.
Thank you, Mr. Chairman. The substitute eliminates the option of the original bill filed to provide a copy of the nonprofit's audited financial statements in lieu of the nonprofit's records, books, and reports, and instead clarifies that nonprofit corporations are only required to provide copies of their annual tax return, which is IRS Form 990, and the organization's application for tax exemption upon request. This change will align the state's nonprofit disclosure requirements with federal laws so they can mirror one another. By detailing exactly which documents are subject to disclosure, nonprofits will have a clear understanding of which documents they must produce to the public and eliminates the possibility of requesters misusing this statute. There are a few witnesses here, and hopefully they'll be short. And if there are no questions, I'd like to reserve the right to close, but I'm happy to answer any if you have them.
Members, any questions for Speaker Guerin? Thank you very much, Speaker.
Thank you, Mr. Chairman.
Proceed to testimony. Chair calls Christopher Bowman. And we show you registered as Christopher Bowman on behalf of the Houston Livestock Show and Rodeo as President and CEO, testifying for the bill. Is that correct?
That's correct. Good morning, Mr. Chairman and members of the committee. My name is Chris Bowman. I'm President and CEO of the Houston Livestock Show and Rodeo. I'm here to testify in support of House Bill 1957. The rodeo is about promoting agriculture and supporting Texas youth through scholarships and educational programs. This year, we just finished our 91st show, and this year our total award will be $575 million to the youth of Texas since 1932. We support Section 22, we support the bill, House Bill 1957. Section 22 of the Texas Business Organizations Code requires nonprofit organizations to keep records, books, and annual reports of the organization's financial activity and make those documents available to the public upon request. However, the code does not define what these documents are. As a nonprofit organization that is required to comply with this requirement, the lack of clarity as to what is considered a record, book, or report leaves organizations like ours subject to releasing information that is otherwise sensitive or confidential. As a nonprofit organization, particularly one with numerous members and partners, we conduct countless transactions and handle documents that can include confidential and/or sensitive information related to the organization's financial activity, like our scholarship recipients. Without a clear understanding of which documents we are required to provide, organizations are left with the unfair position of possibly releasing confidential information that would otherwise be protected or withholding information that would make us run afoul of the law. Furthermore, without clarity, there is nothing that stops a requester from making multiple requests for information that goes beyond the intended purpose of the statute. The committee substitute for House Bill 1957 will help address the issue by ensuring the state's disclosure requirements mirrors federal law. Thank you, Chairman Guerin, for filing this bill to help provide clarity to nonprofit organizations. I urge this committee to pass the committee substitute to HB 1957, and I yield for any questions from the committee.
Thank you very much. Members, any questions for Mr. Bowman? Representative Lambert?
Thank you, Mr. Chairman, and thank you for your testimony today, and just congratulations on another very successful Houston Stock Show and Rodeo. Just a quick question. I come from a kind of a rural area. A lot of our nonprofits are very small. This does not require them to get an audit. This does not require them to go to the extreme of trying to protect their confidentiality as far as the privacy information, correct?
Correct.
Okay, thank you.
Members, any questions? Thank you very much, Mr. Bowman.
Thank you.
Is there anyone else left? Nope. Anyone else who wishes to testify on, for, or against House Bill 1957? If not, the chair recognizes Speaker Guerin to close.
Thank you, Mr. Chairman and members. 1957 just protects nonprofits from people that will come and harass them by asking for documents that they really have no business seeing. And I would ask for favorable consideration, and I'm happy to stand for any questions that you might have.
Thank you, Speaker. Members, any questions?
I close. Thank you, sir. Thank you, members.
Thank you. The committee substitute to HB 1957 is withdrawn. If there's no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. All right. The chair lays out House Bill 2295 and recognizes the Vice Chair with suit to explain the bill, and this is Representative Hefner's bill relating to liens on aircrafts for certain charges.
So treat me gently. I know what an aircraft is, but I don't know much else, so let me read this. Thank you, Mr. Chairman and committee members. I appreciate the opportunity to bring before you House Bill 2295. And by the way, this is Cole talking. Texas law grants a lien to a person who stores, fuels, repairs, or performs maintenance on an aircraft until payment is made for the services provided. However, unlike other types of liens, current law does not fully protect our Texas aviation fuel providers. House Bill 2295 seeks to address this problem by extending aircraft lien authority to ensure those who contractually purchase fuel with Texas companies under Texas law can be held to payment terms by those who provide those services, regardless of whether the fueling occurs in Texas or elsewhere, including outside the United States. This is appropriate given that aircraft rarely stay in one place for very long, and Texas aircraft fueling companies have networks of supply contracts with national and multinational oil companies, local fuel providers, and agents that pump fuel into their customers' aircraft at over 3,000 airports in 212 countries worldwide. House Bill 2295 is identical to a bill that unanimously passed this committee in the 2019 session, and I would request your favorable consideration of it once again. I believe we have a witness here today who will speak to these points. Members, at this time, will be happy to answer any questions you may have. Again, I know what an aircraft is, but not much else.
Members, any questions for Vice Chair Vasut? All right.
Reserve the right to close.
Well, then we'll proceed to testimony. Chair calls Robert Kruckmeyer. And I hope I said that correctly. And we show you registered as Robert Kruckmeyer on behalf of Associated Energy Group testifying for the bill. Is that correct?
Correct. Thank you. Thank you for your time. Mr. Chairman, members of the committee, thank you for the opportunity to speak in support of HB 2295. My name is Robert Kruckemeyer. I am counsel to Associated Energy Group. It's a Woodlands-based aviation fuel distributor. AEG, as we're known in the industry, sells jet fuel to cargo airlines, charter operators, governments, and fixed-based operators all over the world. Its network consists of 2,000-plus suppliers and agents in 197 countries, providing coverage at more than 3,000 airports. So from time to time, AEG and other Texas companies like them find themselves litigating to collect unpaid fuel bills using Texas lien law as their recourse. HB 2295 clarifies the current statute to ensure services offered by Texas fuel providers will be better protected under the Texas aircraft lien laws, regardless of whether the fueling occurs inside or outside the state of Texas. This is an important clarification that will better protect Texas fuel providers from those who wrongfully seek to avoid payment for the aircraft fueling services. Thank you for your time and attention. I would be happy to answer any questions you have at this time.
Representative Lambert.
Thank you, Mr. Chairman. Thank you, Mr. Krugmeyer, for being here. I've been a banker all my life, so I've financed a few aircraft, not very many, but a few. And I was just really one question and a comment. Number one is the comment, and that is any liens filed on fuel, I guess, would probably, in most cases, become a secondary lien, correct? I mean,
It would, yeah. Yes, sir.
because most of the time, the banks or the lenders are going to have the first lien, and it was a purchase money lien and so forth. So
Exactly.
in the question really I have is, doesn't the property code currently cover fuel sales liens? And so you kept saying it's going to make it better. Explain what it's going to do.
Yeah, so what happens, let me give you a pretty simple example. You know, we have a charter company, say, and they fly from Houston down to Cancun, maybe over to Phoenix and back to Houston. Well, each place we have fueled them, say, $30,000 worth of fuel each, right? Under current law, it's unclear whether or not our lien extends for their total fuel bill or for only the fuel that they got in Houston. We say it should cover the entire fuel bill. The current lien statute doesn't address it, and it's unclear. So there's no Court of Appeals opinions about this, but, you know, we're trying to just make it, you know, crystal clear that when you, purchase fuel from a Texas fuel company, and part of it's in Texas, but part of it may be in Mexico, and part of it may be in, Arizona, that when we send you the entire bill, well, you're not going to divvy it up and say, well, we only can lean up the aircraft for a portion of the fuel that you purchased from us.
So this just expands it beyond the borders? as
Well,
far as-
we think it already exists beyond the borders under the current law, but it's not clear. This is just clarification.
Okay, thank you.
Members, any questions from
I got
Representative
Thank you,
Frazier?
Chairman. Just run me through a scenario where this is happening, and how often does it happen?
Well, you know, we have a network of FBOs and places, 3,000 airports where we fuel. So again, it would be the scenario I just talked about. You know, we have a charter, we cargo, anybody like that. I mean, these are for big players. This is really not for, the single aircraft owner who's going to run down to Cancun and back. This is for, big players that have a lot of, they have a big fuel bill. And it would be a situation just like we talked about, and this does happen where, we have Frazier Cargo or Frazier Charter Services.
That would be good, by
Yeah,
the way.
yeah. So, we fuel them up in Houston. They go down to Mexico with the spring breakers or whatever. Then they've got to take a plane load of spring breakers back to Phoenix, right? And then they're coming back to Houston. And we have a fuel bill of, say, $90,000, right? And we send them the fuel bill and they're not paying. It's like, okay, well, we have a lien on your aircraft. And they say, well, we only put $30,000 worth of fuel in Houston, and therefore the lien's only for $30,000, even though we owe you $90,000. So we're just trying, and we think under current law, we still have a lien on the $90,000, but it's not clear. So that's what we're trying to do, is just clarify the law that says, okay, you fuel with a Texas company, obviously aircraft, mobile, go everywhere. We don't want to hamstring the company by saying, well, you can only piecemeal it and only put a lien on just the fuel that was pumped in Texas. It should be all the fuel that you contractually purchased from us, no matter where it was fueled.
I guess my question is, so when they fuel in Mexico, that's not your fuel?
No, it is. Yeah.
It is?
Oh, yeah.
Okay, so it's the same fuel?
Yeah, same
Like
fuel.
I don't have a plane.
Yeah, we've got fuel everywhere in the world.
Okay, that makes more sense now. Thank you.
Members, Madam Chair Nyave?
Thank you. Is there precedent in other areas of code where a lien for things that occurred outside the state or the country would, a Texas lien would extend to that?
I'm not aware of that. I'm not aware of a code that specifically states that. There are other, codes that people try to enforce that and they think it's unclear or whatever. What we're trying to do here is, to clarify to make sure everybody understands what the playing field is.
Thank you.
Representative Lambert?
Yeah, thank you, Mr. Chairman. Just to clarify, I think like in farming, if you move cattle from Texas to Kansas, you've still got a lien on that cattle. So I think it does apply in the Uniform Commercial Code. So
Okay.
just to answer that.
Oh, excellent. Thank you.
Thank you, members. Any questions? Thank you. There's no one else?
Oh, thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 2295? If not, the chair recognizes Vice Chair Vasut to close on HB 2295.
Well, in the course of reading my script and hearing the questions, I like this bill. And it seems to me that we're making sure that people with private jets and cargo planes are not skimping out on their bills with Texas companies. So I think that's a good idea to make sure that we protect Texas business. And Mr. Chairman, members of the committee, I respectfully request your favorable consideration of this bill and send it to local and consent, if you please. Thank you very much.
Thank you. If there is no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. Chair lays out House Bill 2194 and recognizes Representative Ordaz to explain the bill. Vice Chair Vasut offers a committee substitute to HB 2194.
Morning. Chairman Longoria, Vice Chair Vasut, members, thank you so much for giving me the opportunity to present this piece of legislation. I have a committee substitute that I will explain during my layout. You should have an explanation of changes also in your materials. I bring present for you consideration of a piece of legislation that you may be surprised to learn that we need. The federal government's Made in the USA program is widely recognized, promoted, and a point of pride for our nation's businesses. In 2020, the Reshoring Institute found that nearly 70% of survey respondents preferred American-made products, with more than 83% willing to pay a premium of up to 20% for domestic-made products. A 2021 survey by the Reshoring Institute found that only 6 states have a Made in Your State program. Products that are made in Alaska, California, Connecticut, Indiana, Ohio, and Virginia have labeling standards so citizens know they are buying products that are genuinely made in those states. It's time to do the same in Texas. House Bill 2194 would create a Made in Texas labeling standard requiring proper and transparent labeling to identify when the majority of a product is made in Texas. Having an accurate Made in Texas label promotes product sales. In addition, it will positively impact our local economy and encourage other businesses to move more of their production to our great state. The language in this bill reflects the same guidance provided by the federal government's Made in the USA program, which is that a product must be wholly or substantially made in Texas. The committee substitute changes the authority of creating the standard to the Economic Development and Tourism Office, raises the maximum fine to $1,000 to align with similar fine structures already in place in the AG's office, and provides a 30-day right to cure for businesses that are in violation of the law. As part of this legislation, EDT will create a Made in Texas logo and the assessment process for the use of the logo. To promote Texas businesses, the Made in Texas logo will be free and available for anyone to use if their product meets the criteria, making it accessible to small and large business owners. This is a simple initiative that will bring enthusiasm and excitement for our state products and our small and large businesses. It will not cost any state funds and will even bring more Texas pride into our products. Thank you, Chairman Longoria, Vice Chair Vasut. Members, I'm open to answer any questions and reserve the right to close.
Members, any questions? All right, we'll proceed to testimony. Chair calls John Espinosa. we show you registered as John Espinosa on behalf of the Texas Hispanic Chamber of Commerce Coalition testifying for the bill. Is that correct?
That is correct. Good morning, Chairman Longoria, representatives. My name is John Paul Espinoza, and I serve as the Senior Manager of Public Policy and Economic Development for the Greater Austin Hispanic Chamber of Commerce. And I'm here on behalf of the Texas Hispanic Chamber of Commerce Coalition to testify in support of House Bill 2194. The Texas Hispanic Chamber of Commerce Coalition, THCCC, was launched in December of 22 to provide a united voice for Hispanic businesses and Hispanics in business in Texas, and is comprised of the 9 largest Hispanic chambers in Texas, including the Austin Hispanic Chamber of Commerce, Brazoria County, El Paso, Dallas, Fort Worth, Irving, Midland, RGV, and San Antonio Hispanic Chambers of Commerce. In total, the coalition represents over 6,000 businesses across the state of Texas. The THCCC's mission is to advocate for statewide policies that support economic contributions and the spirit of Hispanic businesses and Hispanics in business in Texas. On behalf of the coalition's more than 6,000 members, I am here to express our support of House Bill 2194 by Representative Claudia Ordaz. In 2020, the Reshoring Institute found that nearly 70% of survey respondents preferred American-made products, with more than 83% willing to pay a premium of up to 20% for domestic-made products. The federal government's Made in the USA program is a point of pride for many businesses across America and shows that citizens buy products and support American-owned businesses. It is this time that Texas, the 9th largest economy in the world, have a Made in Texas program. A Made in Texas program would be a point of pride for so many small businesses across the state of Texas and the residents of the state as well. Most importantly, it would have a positive impact on our local economy and encourage our other businesses to move their production to the state of Texas. On behalf of the more than 6,000 businesses of the THCCC, we ask your favorable consideration for House Bill 2194. Thank you.
Thank you. Members, any questions? Madam Chair Nave.
Thank you, Chairman. I just want to thank y'all for your testimony and for all the work that y'all are doing in our communities and helping grow Latino and Latina-owned businesses.
Thank you. Members, any questions? Thank you very much.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 2194? If not, the chair recognizes Representative Ordaz to close on HB 2194.
Thank you, members. I request your favorable consideration, and I close. Go ahead.
Representative Gonzalez.
So is this going to be part of the Go Texan program, or how's it different?
So the Go Texan program is strictly agricultural products. So that's through the Texas Department of Ag. But if you have, like, say, manufacturing if you have other products outside of ag, those are typically just food products. This is across the board. So the majority of your products are made in the state of Texas, then you would qualify. So, but if you qualify for Go Texan, then you could also qualify for this program. So, but this is for all products generally, not just through ag.
But so the products that are currently a Go Texan product, this is going to require for them to also have a Made in Texas logo on their product now?
Right. And so, I mean, if they choose to. So currently, it's only food products. They would qualify. This is more of an incentive program because with the Go Texan program, unfortunately, you have to pay into that program. It's not necessarily an incentive. For this program, it's free. It's open for all businesses, small and large alike. Through the Department of Ag, through the Go Texan program, it's only for food products.
Okay.
So they would qualify under this, and that is included in the committee substitute.
Okay. No, because I'm just looking at this one section that says that that they shall enter into an agreement and that whatever products are a Go Texan partner, is it also, okay, so is it also, or is it they have to? It's
No,
discretionary?
they don't
Okay.
have to, but
All
they
right.
qualify.
All right. That was
So currently, let me just explain that. So the Go Texans program is through the Agricultural Commission. It has its own application process, requires a minimum payment of $500 to belong to the program. This one would not have any fee. And there would be no fee to use the Made in Texas logo. And this is not a buy-in program. This is simply just a labeling standard that will be equally available to all.
Okay, thank you.
Thank you, members. Any questions? Thank you.
Any other questions? Okay, I close. Thank you.
Thank you. The committee substitute for HB 2194 is withdrawn. Is there no objection? The bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. Chair lays out HB 2702 and recognizes Chairman Guillen to explain the bill.
Thank you, Mr. Chairman. Members, a designated doctor is an independent doctor certified by the Division of Workers' Compensation to answer questions about work-related injuries or occupational illnesses. Designated doctors are critically important to injured workers and the Texas economy. These doctors do not treat injured workers, rather they examine them and determine whether the worker can or cannot work. And importantly, they pay their own expenses to travel to these examinations. Currently, there are 238 designated doctors participating in the program. That's down from just over 1,600 in 2008. This exodus from the program is threatening its long-term viability. Last session, when I presented this exact same bill to this committee, there were 311 designated doctors. It's now down to 238. While the division has made an effort to make the program more appealing to doctors, the problem is clear. The fee schedule for exams performed by designated doctors hasn't increased in over 20 years, and inflation alone is making the program less and less attractive each year. In addition to inflation, pay for designated doctors has decreased in another way too. They used to receive a $100 no-show fee when an injured worker failed to appear for a scheduled exam, but that fee was eliminated. So currently, designated doctors can incur expenses for these exams only to have the worker not show up, and then the doctor doesn't get paid. HB 2702 will bolster the program by reinstating the no-show fee and by increasing exam fees to account for inflation and also allow those fees to be adjusted in the future. This bill will go a long way to protect the viability of the program, and it comes with no fiscal note, and it passed the House on the local and consent calendar last session. I can help answer any questions if y'all have any, and we do have somebody here to testify.
Members, any questions for Chairman Guillen? Thank you, Chairman. If no further questions, we'll proceed to testimony. Chair calls William Lawson. Mr. Lawson, we show you registered as William Lawson on behalf of the Texas Chiropractic Association and yourself testifying for the bill. Is that correct?
Yes, sir, it is.
Thank you.
Thank you, Mr. Chairman and members. My name is Dr. Bill Lawson, and I'm here to testify in support of House Bill 2702 on behalf of myself as well as the Texas Chiropractic Association. I'm the president of the Texas Chiropractic Association, and I have 24 years of experience as a designated doctor. Representative Guillen, thank you so much to you and your staff for all the work you've put in on this issue. Designated doctors are independent doctors who help ensure the injured workers receive treatment that they need, and it provides a big value and a cost savings to Texas employers as well as the workers' compensation carriers. But as you've heard, the designated doctor program is in trouble. According to the Insurance Council of Texas, there were more than 1,200 designated doctors in 2012. The latest tally shows that there's 238, and that's as of February of this year. The program is hemorrhaging participating designated doctors, and if it keeps this up, it is doomed to collapse. To be clear, this isn't the fault of the division. They've done an admirable job of trying to make the program more attractive through rulemaking. The problem is designated doctor compensation. Most of the designated doctor fee schedule that we have was set back in 2003, and it remains unchanged today. For example, a fee for an examination to determine if an injured worker is or is not at maximum medical improvement is $350, and that was established in 2003. Today, 20 years later, it's the same amount, $350. According to the Bureau of Labor Statistics, $350 in August of 2003 had the buying power of just over $570 at today's time. The program simply isn't staying competitive enough to recruit or retain doctors. In addition, the elimination of the $100 no-show fee has created a burden. Eliminating the fee means traveling to a designated doctor exam, which is at the expense of the designated doctor. If the patient no-shows, there's no reimbursement at all. The designated doctor pays his way, rents a room in which to do the examination, and is out that money. $100 in no way reimburses the doctor completely, but it's a little bit of something, maybe to pay for the gasoline and the time away from the clinic, and it takes away the sting and the discouragement that we face. House Bill 2702 will help the division recruit and retain more designated doctors, hopefully reversing the program's declining numbers. The program has been a major success, providing a valuable service to injured Texans and a cost saving to Texas employers and the workers' compensation carriers. But it needs help, and if it's going to survive, House Bill 2702 provides that help. Thank you, Mr. Chairman, committee members, for your time and consideration, and I'm open to any questions that you may have.
Members, any questions? Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against HB 2702? If not, the chair recognizes Chairman Guillen to close on the bill.
Thank you, Mr. Chairman. If there's no further questions, I'd ask for your favorable consideration. And we are working on a minor committee sub to change a few little things that we'll get back to you as soon as possible.
Members, any questions? Thank you, Chairman. If there's no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. Technical difficulties. All right, the chair lays out HB 2545 and recognizes Chairman Capriglione to explain the bill. Representative Lambert offers a committee substitute to HB 2545.
Good morning, Mr. Chairman, Chairman Longoria, members. There is a committee substitute, if you lay that out. Okay. Mr. Chairman, members, thank you for the opportunity to address the committee. Today, I'm here to speak to you about House Bill 2545, which will protect consumers' genetic information. Many websites allow individuals to explore their familial heritage through at-home DNA testing kits. Direct-to-consumer DNA kits also allow individuals to assess their potential health risk by predicting genetic illnesses. These products have grown increasingly popular, with over 50 million Americans using them in the last 5 years. However, there are no state or federal laws that prevent these companies from selling our personal genetic information, or even basic protections to ensure that these companies anonymize our data to prevent identity fraud. This lack of government oversight was cited by the Department of Defense last year when they advised service members and their families not to use genetic testing services. Our genetic information is the most personal identifying information we have. Someone gets your credit card, you can cancel it. If someone gets your ID, you can order a new one. When our genetic information is shared to third parties we did not consent to, that damage cannot be undone. House Bill 2545 will ensure that that does not happen. Now, while some of the more popular direct-to-consumer DNA testing companies do not sell customers' data, there are over 50 other lesser-known DNA companies, and that number continues to grow each day. Without laws in place, customers are at risk of having their genetic information shared for targeted advertising, insurance profiling, or even criminal activity. House Bill 2545 requires genetic testing companies to receive express consent from the consumer before sharing their genetic information with a third party, using the genetic data for a purpose other than the service purchased by the consumer, or retaining a sample after the testing is completed. In all other cases, the data must be completely de-identified to be retained. The only exception to this is if a law enforcement agency requests the information through a warrant. Any violation of the bill will result in a civil penalty per violation, and only the Attorney General's office can bring penalties under the bill. House Bill 2545 will give consumers peace of mind that they can use genetic testing services without risking their privacy and safety. Happy to take any questions. I reserve the right to close.
I think I had said it, but Representative Lambert offers a committee sub to HB 2545.
Yes.
Representative Hinojosa?
Thanks, Representative Capriglione. You bring fun, complicated, and important bills, and I appreciate this one. There's a section in Section 503A.006, prohibited disclosure, and it prohibits disclosing genetic data to law enforcement without first the individual's express consent or obtaining a warrant. Is this not already the law?
Well, no. So what we found in some privacy issues, and there's articles you can read what's happening in, at least in the privacy realm, where some companies will offer it up without a warrant. They'll sell it. And so some of them, if there's an inquiry by law enforcement, for instance, they might give that information. What we're saying also as part of that section is you have to specifically opt in and know what you're opting into. So that's specific written consent. If you don't provide that, then no one can get it unless there's a subpoena or a warrant from a law enforcement, a court-ordered one. It is not the law today. That information could be sold. That information could be given to anyone. And so what this bill does is it sets up a parameter that you cannot do that unless you specifically say, they can, which I would imagine very few people would want to do that.
I appreciate it. It seems obvious to me that someone should need a warrant or express consent to give that information to law enforcement. Only the Attorney General can enforce the provisions of this bill, and I'm wondering why DAs aren't a part of.
We originally had that, and that's what the committee substitute does. We had essentially decided that the state Attorney General's office is the one that's the most capable and has the resources to actually go after some of these companies. Some of these companies are not based in Texas. Some of the companies are, like we said, they're smaller, and so that requires maybe significant effort that would be needed. There's very few in Texas that are in counties, for instance, right? So we decided that the Attorney General's office is the one that's the most capable of making this enforcement. We wanted one place to do this. And the fine is, I don't know if I said it, but the fine is $2,500 per violation. So if there's a company that, discloses or provides access to 1 million, and it's 2,500 times 1 million. So it could be a pretty significant penalty.
Thank you, members. Any questions? Madam Chair Nyave?
Thank you, Chairman. I guess to the point in terms of the penalty, is there a reason why individuals wouldn't be able to bring a cause of action for violation of their privacy under your bill for genetic testing?
Well, I've working on other bills, not in front of you today. That's kind of the effort that we've been making is to make them significant violations as opposed to creating a private right to action or something like that. So it's just kind of the philosophy I've seen in all the successful privacy bills across the country.
Thank you.
Thank you, members. Any questions? Thank you very much. We'll proceed to testimony. Chair calls Richie Engelhardt. And we show you registered as Richie Engelhardt on behalf of Ancestry, testifying for the bill. Is that correct?
That is correct. So good morning, Mr. Chair and members. I am Richie Engelhardt, Head of Government Affairs with Ancestry. Here today on behalf of the Coalition for Genetic Data Protection in strong support of House Bill 2545. Ancestry is proud of the work we've done with our coalition partners, including 23andMe, to implement common sense privacy protections that ensure consumers are in control of their genetic data at all times. The work on this bill dates back to 2017 when the Future of Privacy Forum, a leading privacy nonprofit in DC, convened consumer and privacy advocates, medical ethicists, companies, and legislators on the Hill. Together, they developed a privacy best practices document that includes what we believe are the appropriate guidelines for DTC genetic testing services. When states looked to regulate the industry a few years later, those best practices were translated into bill form. That bill before you today requires consumers to provide separate express consents. That means we cannot just bury the consents in our terms of service or privacy policies for any collection, processing, or sharing of genetic data. The bill requires separate express consents for all of the following. For analyzing a consumer's biological sample, storing the biological sample after it's been analyzed for future testing opportunities. And I'll note that's completely optional. If the consumer decides to not bank their sample, they can still use the product. Viewing genetic relatives on our websites, and both consumers have to consent. It's a two-way opt-in before that match is revealed. Using a consumer's genetic data for marketing purposes. And I'll note neither Ancestry nor 23andMe use genetic data for marketing. It doesn't pass the creepiness test for us. But we strongly believe if somebody wants to use this type of personal information for targeted advertising, you should have to get a separate consent for that. Participating in research. And if a consumer opts into research, that actually gets kicked into an informed consent process. All of the research that our companies do are governed by institutional review boards, same as any clinical trial or human subject research in the US. And then finally, sharing genetic data with any third party would require a separate express consent. So HB 2045 also empowers consumers to delete their data at any time and have a biological sample that they provided destroyed if they decide they no longer want it in storage. They can end their relationship with our companies and we retain no rights to their genetic data. This approach has broad bipartisan and stakeholder support. Since 2021, 6 states have enacted this approach: Arizona, California, Kentucky, Maryland, Utah, and Wyoming. And this year, there's about 6 more states that are on track to enact similar measures. The bill in Virginia is sitting on the governor's desk right now. If passed, HB 2545 will ensure that every direct-to-consumer testing service is held to the same standards for privacy and data protection. And the bottom line is our consumers' trust is our top priority. If they don't trust us, they're not going to use us. So we want to thank Representative Capriglione for his work on this bill over the past few years, and we urge a favorable report. And I'm happy to answer any questions you may have.
I just have some clarification. So you mentioned the coalition, but you're registered on behalf of Ancestry. Are you testifying?
So I work for Ancestry. We work closely with 23andMe. I don't represent them officially, but they are in line with the bill's provisions.
Okay, but today you're testifying just on behalf of Ancestry?
Correct.
Okay. All right, thank you. Members, any questions? Thank you very much.
Thank you, sir.
Chair recognizes Gregory Porter.
Good morning.
Morning. We show you registered as Gregory Porter on behalf of yourself, testifying for the bill. Is that correct?
Yes, sir, that's correct. I didn't bring my little ones with me today. I appreciate you guys having me today, Chairman Longoria, Vice Chair Vasut. I actually had a chance to sit with both Spencer and Representative Capriglione last week, which was a wonderful meeting. I really appreciate what's been done on this bill. We went through some of the details, and I feel like this has been broadly addressed, and I support it. I'll save, kind of further comments and keep the meeting short, but the only recommendation that I would make, and I talked to Spencer about this, would be to potentially slightly increase the civic charge, maybe something to more like a $7,500 amount. It was my understanding that that's kept lower because the aggregate amount of those charges could ultimately reach a threshold of how much a lawsuit could be. My sense would be you want to have some kind of penalty there that really incentivizes these large corporations to kind of act in this direction. But in terms of the layout of the law and the specific consent requirements and so forth, I think it's very thoughtful, and I just wanted to be here in support of that, and appreciate you hearing me speak.
Thank you. Members, any questions? Thank you for making out today.
Thank you.
Thank you.
Yep.
Is there anyone else who wishes to testify on, for, or against HB 2545? If not, the chair recognizes Chairman Capriglione to close on HB 2545.
Mr. Chairman, members, thank you for considering House Bill 2545. Since you get what you don't get, what you don't ask for, respectfully see if local consent is an option, but if not, thank you, and I close.
Representative Hinojosa.
Would this bill, I'm thinking specifically of the delete the information portion of it, apply to data that these companies already possess?
It would remove the data What do you mean? So like
So
the
like, if
genetic
I did this
information.
last year,
Yep.
and they have my data, and, which I didn't.
Right.
But if I did this last year and they have my data, and now this bill passes, becomes law, can I
Yes.
have that data? Can I say, I want now that data
They
removed?
would be required to delete any data that they have once this becomes effective.
Okay.
And if you did do it, you should delete it. But anyway.
Well, I'm more likely to do it if this becomes the law.
Right.
Thank you, members. Any questions?
Right. I'm good. Thank you.
All right, thank you, Chairman.
Mr. Chairman.
The committee substitute for HB 2545 is withdrawn. If there's no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. Chair lays out HB 1242 and recognizes Madam Chair Hernandez to lay out HB 1242 relating to the eligibility for unemployment compensation of certain employees who leave the workplace to care for a minor child.
Thank you, Mr. Chairman. Laying this out for Representative Hernandez. House Bill 1242 would prohibit unemployment insurance applicants from being disqualified for consideration if they voluntarily left the workplace to care for their minor child due to an unforeseen emergency where there was no reasonable alternative care. And the issue facing our state is that essentially when working parents are being forced to choose between workplace obligations and their children back home, especially during unexpected emergencies like illness, school closures, sudden failure of childcare arrangements, and more. And during the pandemic, more than 700,000 Americans left the workforce. 2/3 of those were women, primarily due to problems associated with childcare. To ensure protections for working parents in the midst of the pandemic, Governor Abbott issued guidance to the Texas Workforce Commission to extend unemployment benefits eligibility to individuals that were unable to return to work due to a child's school or daycare being closed and no alternatives were available. So this extension served as a lifeline for many families during the early months of the pandemic, but the struggle that working parents face with childcare issues extends beyond the pandemic. Many working parents can relate to these difficult decisions and know what they would risk to ensure the safety of their little ones back home. Parents need clarifying language in our unemployment code to make better, more informed decisions when weighing the consequences of leaving the workplace. Unemployment eligibility should be more closely aligned with the current work-life conditions of thousands of Texans. House Bill 1242 amends the Texas Labor Code to include cases in which an individual must leave the workplace to care for their minor child due to an unexpected and unforeseeable event and is involuntarily terminated. The Labor Code provides for instances of involuntary separation due to a compelling need, such as family violence, sexual assault, and caring for a terminally ill spouse. However, there's no guidance currently for an instance of a minor child emergency. This bill does not require or mandate that the Texas Workforce Commission approve each claim. Applicants are still subject to the same standard of scrutiny and must meet numerous requirements. House Bill 1242 updates our labor code to more accurately reflect the current needs of Texas families and to help them get back on their feet and re-enter the workforce. Unemployment affects us all. A fellow Texan who has lost their source of income cannot support our local economy. The point of unemployment insurance is to help Texans get back on their feet and re-enter the workforce. HB 1242 will grant parents the confidence that attending to their minor child in times of emergency will not be held against them, while still allowing TWC the discretion to evaluate applications on an individual basis without any mandated outcome. And on behalf of Representative Hernandez, I reserve the right to close.
Thank you, members. Any questions? Representative Lambert?
Thank you, Mr. Chairman. And Chairwoman Neave Criada, I'm not trying to put you on the spot, but do you know anything about the fiscal node and how that might be addressed?
I don't, but I can look. in the book. I don't have an answer for you, but I'm happy to get with Representative's office. And actually, the notes say there's no fiscal implication to the state, so no fiscal note.
Not sure. Okay, thank you.
Thank you.
Members, any questions? We'll proceed to testimony. Thank you. Chair calls Annie Spillman. And we show you registered as Annie Spillman, State Director for NFIB. testifying neutral to the bill. Is that correct?
Yes, yes. I am Annie Spillman with NFIB. We represent a little over 22,000 small business owners around the state, and testifying neutral on the bill. And I generally don't like when lobbyists do that, but I'm only doing that so that I can make some comments. Not opposed to House Bill 1242 exactly, because we understand the conditions that some of these workers are in. I just want to remind the committee, because you'll probably hear several bills that when we're adding to what qualifies for UI, it results in a tax on our small businesses. And if you'll recall, we were happy that last session the legislature approved we got ARPA funds, federal money, and so we were able to replenish the UI trust fund last session because obviously it was overused due to COVID. And so the state debt was covered through that ARPA money instead of a tax onto our small businesses. So that prevented that tax increase on our members. So we were happy about that, and they need some predictability on this employment tax rate in the future. So the more we're sort of adding to what qualifies for UI, that's a tax. That's why you don't see a fiscal note on the state. That's a tax on our employers. And so I will tell you, Representative Lambert, that the fiscal note does say that it will increase claims. They're averaging about 210 claims per year due to the provisions of the bill. The claims will result in a total cost of approximately $1.44 million in fiscal year 2024. It'll go up from that to about a little over $1.5 million in 2025, and they're thinking that the 5-year total cost would be close to $8 million, so at $7.9 million. And again, at this point, just so that we know that we're probably going to see maybe some other proposals that'll continue to add to that qualifications for UI, and know that that's going to be a tax implication on our small business owners that are already dealing with a lot of issues trying to keep their doors open right now. So,
Members, any questions? Representative Hinojosa?
Thank you. Have you gotten with the author of the bill about your concerns?
no, because we're not opposed. And actually, when it got posted, I was attempting to go over there, and just everything else happened. So I was going to go and chat with her this morning. We don't want to stand in the way or amend it. We just want to give a heads up on sort of where that money, sort of the backs that it falls on, ultimately then kind of ends up hurting the employees. But no, had not had a chance to talk to her, and that's why I'm not here opposed.
Okay.
Yes.
Yeah, I think I would encourage you to make that time.
I will.
You've expressed concerns that I think potentially could give some members pause, and so even though you're on the bill, I think if y'all could kind of figure something out together, that would be helpful.
We will. I know. It's always my intention to talk to the bill author before. It's one of those things.
Representative Gonzalez?
Quick question. What percentage does the employer pay in for unemployment?
Oh, God, that's a really good question, and I know the answer. I'm so
Because
sorry.
doesn't it work that way, that a percentage of
It's a percentage based also, too, on your, on how many folks you employ in your payroll. And I can get you the answer. It's just not right on the top of my head. I'm sorry. But you're right.
But the employer does pay a percentage?
Yes.
Percentage of, okay.
Yes, yeah. So, yeah, I mean, it's sort of a pro rata. It's not like it's all just split up between all the businesses. So, a small business might pay a little less into this system, but it's almost like an equal burden just because they're a smaller business. But,
Madam Chair Niabe?
During the past, since the pandemic, the number of unemployment claims has decreased, has it not?
You'd have to ask TWC. With our members, I would probably agree with you, but it's because they haven't even begun back to sort of refill the positions. 60% of our members have positions that they cannot fill at this time.
Yeah, and I think my point is that they have significantly dropped unemployment claims throughout the past few years. In fact, we have one of the lowest unemployment rates, from my understanding, here in Texas. So these are circumstances where it would be extreme emergency situations for a parent taking care of a child, and so which would probably be a very small I would think, amount of people seeking.
I think so because LBB is saying, at this point, and this is why this wasn't like a big one of those, bills that we were going to stand in the way of. But I think, LBB says it estimates the UI Trust Fund would see an increase of approximately 210 claims per year. So
Right.
I'd
So
say
it wouldn't
that's
be a significant.
no,
tax
that's what
on
I'm,
it, like
I
you were
agree. I don't think
justified,
that's a
right?
huge
Okay,
amount
thank
of
you.
claims. I agree. Yeah.
Thank you, members. Any more questions?
Thank you for your time.
Chair calls Eric Holman. And we show you registered as Eric Holman on behalf of Texas Workforce Commission as the Interim Director of Unemployment Insurance, testifying neutral to the bill. Is that correct?
Correct. Good morning, Chairman and Representatives. Eric Holman with Texas Workforce Commission. I'm here as a resource witness for House Bill 1242.
Members, any questions? Well, thank you. Chair calls Emily Amps. And we show you registered as Emily Amps on behalf of Texas AFL-CIO and yourself testifying for the bill. Is that correct?
That is correct. Chairman Longoria and members of the committee, my name is Emily Amps. I'm the Director of Politics and Policy at the Texas AFL-CIO. I'm here to testify in favor of House Bill 1242 on behalf of our 240,000 members across the state. I also registered in support on behalf of myself as a mother of an 11-year-old. As a mom, I've been fortunate that I've not had to make a choice between my job and caring for my son for an extended period of time. I'm also very fortunate to work for an organization whose mission it is to support and improve workers' lives. I have no doubt that I would be provided the support I need to take care of my child if he were injured or if he received a serious medical diagnosis and no other accommodations were available. But I also know that I am among the minority and that most Texans do not have the same level of support from their employers, especially Texans who make lower wages and who probably need this type of support the most. In debates over bills that impact worker protections, I often hear business owners say that they treat their employees, quote, like family. I appreciate the sentiment, but when a child is diagnosed with cancer or sustains broken bones in an accident, the caregiver's employer still has shifts that need to be filled, customers served, hotel rooms cleaned, and houses built. As a result, these workers are put in a situation where they must decide between keeping their job or caring for a child. This decision is made even more difficult because there is not a safety net of unemployment insurance benefits available to them. If signed and passed and signed into law, this will provide some level of protection for these caregivers and their families. State statute already allows for UI benefits to be considered for spouses if their spouse is terminally ill and no reasonable alternative care is available. This bill would simply afford a similar benefit to a child's caregiver. Last session, this bill was voted out of committee quickly and received a great deal of bipartisan support on the House floor, and I hope that this session will be no different. Thank you, Chairman and members, for your time. I'm available for any questions that you may have.
Thank you, members. Any questions? Thank you.
Thanks.
Is there anyone else who wishes to testify on for or against HB 1242? If not, the chair recognizes Madam Chair Nyave Criado to close on the bill.
Thank you, Chairman. I close. Oh, sorry. I close.
Is there no objection? The bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. All right. Chair lays out HB 4279. Representative Gonzalez offers a committee substitute to HB 4279. Members, this is the committee substitute to HB 4279 is the biennial update to the Texas Business Organization Code. The committee substitute differs from the file version by making very minor changes to 6 sections of the bill to correct the cross-reference and drafting errors. Corrections are made on cross-reference codes in Section 18 of the bill. Minor drafting errors and modifiers are corrected in Section 22 of the bill. Corrections are made to minor drafting deletions in Section 24 of the bill. Corrections are made to minor rewording drafting errors in Section 36 of the bill. Corrections are made to minor rewording drafting errors in Section 58 of the bill. And it includes a word which was not erroneously deleted in the original draft in Section 53 of the bill. As you know, the Business Organization Code governs the creation, operation of Texas corporations, limited liability companies, partnerships, associations, and all types of business entities. We need to keep the code current, so these laws are ahead of the curve and competitive with other business states. This bill contains numerous substantive and technical amendments in the code in order to accomplish this. Generally, the bill focuses on enhancement to the legal framework for corporations, LLCs, and partnerships in connection with certification and formation, entity names, filing requirements with the Secretary of State, meetings and consents, mergers, termination, or winding up matters. The bill includes numerous non-substantive modifications that make current code provisions more precise and accessible. Overall, the bill encourages the use of Texas-based business entities by keeping the code responsive, up-to-date, user-friendly, and innovative. More importantly, the bill continues to promote Texas as leading attentive business state, which in turn will attract business operations and enhance economic development. We have witnesses that will get into the details of the bill and answer any questions, and a representative from the Secretary of State's Business Filing Division is also available here for a resource witness. And if there are no questions, I reserve my right to close. Any questions? All right then. Chair calls Daryl Robertson. And we show you registered as Daryl Robertson on behalf of the Texas Business Law Foundation and yourself testifying for the bill. Is that correct?
That is correct. I want to thank Chairman Longoria for sponsoring this bill. I'm here as a practicing business attorney from Dallas and on behalf of the Texas Business Law Foundation, which is a 30-year-old organization of Texas law firms, lawyers, and corporations formed to sponsor and support sensible and basic business laws to foster the growth of Texas economy and business. One of the examples of that type of legislation is the Texas Business Organizations Code, which was sponsored by the Texas Business Law Foundation approximately 20 years ago. The code recodified all of the various Texas statutes into one code governing formation of for-profit and nonprofit entities. And every legislative session since then, we've had more than one bill amending the code to update it, keep it up to speed, and to add improvements to the bill. Fortunately, this session we only have one bill to amend the code. This bill, however, contains quite a number of small amendments, substantive amendments, and then quite a few non-substantive, technical, and clarifying amendments. I won't try to list all of the numerous changes. That would take a long time, but I'll mention a few. We've added a provision that allows, in the filing of a restated certificate of formation, the deletion or omission of what might be an outdated initial mailing address of the entity. That was a provision added in the last session, which required a certificate of formation to include the initial mailing address. And of course, the initial mailing address 10 years after the fact might become completely outdated and misleading, so we're allowing entities to omit that when they restate their certificate of formation. Another example is in past sessions, we've added provisions specifically authorizing the ratification and cure of void and voidable transactions and acts by corporations. This bill now contains a simplified version of provisions that allow for the ratification of void and voidable acts and transactions by limited liability companies and partnerships, which weren't covered by the prior provisions. Another provision, lots of lenders in Texas require Texas LLC borrowers to include so-called springing member provisions in their company agreements. We've added a provision that basically recognizes the authority and enforceability of those provisions. Also, we are improving the flexibility of filing of certificates of merger, conversion, and exchange to allow the filing of those certificates with a delayed effective date after the approval takes place by all the different constituencies for the merger, conversion, or exchange. And Last but not least, there is a couple of amendments to the Business and Commerce Code relating to assumed name filings. And I just wanted to mention that it's not solely an amendment of the Business Organizations Code. I want to thank you in advance for your favorable consideration of this bill.
Members, any questions for Mr. Robertson? Thank you. Chair calls Lori Ann Fox. We show you registered as Lori Ann Fox on behalf of yourself testifying for the bill. Is that correct?
That is correct, Chairman. Chairman, representatives, thank you very much for having us here today. I am a private lawyer in Dallas, Texas. I have a small practice. In addition, I'm general counsel for a legal tech startup here in Texas, and I've had the pleasure of serving on the committee that recommends these changes to the business organization codes to make it easier for companies and businesses to form and do business in the state. I think that what we've done over the past 2 years, because we always take a thoughtful approach, is to really enhance the code in order to allow business to stay competitive and allow Texas to stay competitive as one of the top states in the country to do business. Thank you very much.
Thank you, members. Any questions? Thank you. Members, we have a resource witness from the Secretary of State office if anybody wants to ask. All right. Is there anyone else who wishes to testify on, for, or against HB 4279? If not, the chair recognizes himself to close on the bill. And with that, I close. No questions. The committee substitute to HB 4279 is withdrawn. If there's no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to the call of the chair.